So my name is Kimball Parker. I'm the CEO of 650. 650 is the software subsidiary of the law firm Wilson Sonsini. And so I'm just going to tell you briefly about 650, and then I'm going to turn the time over to our panelists who are here. So there are two parts to 650's business. We work with the law firm with Wilson Sonsini to automate complicated compliance areas, and so we have products for the GDPR and the CCPA. But then the other side of our business is pro bono, and so we try to look for opportunities to help people who either can't afford attorneys or in kind of unique circumstances. So this is what kind of brings COVID to our attention. This is such a complicated situation for employers, and so what we've done is we have pulled in some of the best employment experts in the nation. So that's actually that sounds like hyperbole. It's actually true. So Wilson Sonsini has one of the best employment groups in the nation. They have thought through many of the employment implications of COVID. So how to deploy your teams working remotely, what that means legally, and have thought through a bunch of those issues. And so we are very, very happy to kind of introduce our panelists here. Our first panelist is a partner in the New York office for Wilson Sonsini. So Marina, I'm gonna butcher your last name. I'm not even gonna say it, in fact. So I'm gonna let you say it. But her name is Marina, and then Tistalis. Is that right, Marina? How do you say your last name?
It's pretty close. It's Satalis.
Satalis. There we go. And the other panelist, his name is Matt Gorman. He's an associate at a Wilson Sonsini, also in the employment group there. And so I'm going to turn the time over to them. I have slides that I'm going to run for Marina and Matt. And so Marina and Matt, if you can just give me a cue of when to kind of change the slides, I will handle that for you. But the time is yours. Thank you very much.
Wonderful. Thank you, Kimball, and good afternoon, good morning, everybody. Thank you for joining us. This is our second webinar on COVID and the employment law implications for it in a short period of time. And the reason why we felt another was necessary is because, as you know, the circumstances are changing so substantially and so rapidly with regard to our country's reaction to the spread of the coronavirus, including and perhaps even most particularly with regard to the implications on the workplace and on the employment law issues. So as Kimball said, I'm Marina Satalis. I'm a partner resident in our New York office at Wilson Sonsini, and I've been practicing employment law for more than 25 years now. Matt Gorman is a senior associate in our group who's also been practicing for a long time, and we've been focusing on the issues relating to COVID-19 as they implicate the employment relationship, and trying to bring together for you what we believe are the most material issues for employers to be thinking about and practical advice and steps to be taking as we move forward. The number of coronavirus cases, as we see in the news in the United States, keeps increasing. Since our last webinar, it's been declared a pandemic. Healthcare officials and the government on every level are taking new steps daily, really, to keep the pandemic from overwhelming our healthcare system. And you'll see, and you've seen states and localities ordering shutdowns or near shutdowns and other restrictions on businesses. At the same time, the public is being begged to keep their distance from others. And the timeline of this epidemic, really this pandemic, is growing. I'm expecting to be longer than maybe originally expected, 12 to 18 months even, maybe, in terms of restrictions and ramifications of a material nature for the workplace. So as the employment laws change and new legislation is put into effect, We want to discuss with you what the considerations are as you navigate as employers, the new restrictions, the new legislation, the local orders, and what to do to best maintain your operations and your business during this difficult time, how to maintain worker productivity, how to care for your employees and comply with really the myriad laws on leaves and whether they should be paid or unpaid, telecommuting issues, business expenses, all of the issues that come up, and also understanding your options for contraction should that unfortunately become necessary, given our economic state. We will be happy to answer questions. We have so much material to cover, however, that we ask that you submit questions that we will answer at a later point. And Kimball, we can go to the next slide. So these are the topics we're going to be covering. Providing a safe working environment. What does that mean for an employer? What can we do to screen? I'm getting a lot of questions about what can we ask? Can we take temperatures? We'll cover those issues. Leaves of absence, both unpaid leave entitlements. Leave entitlements, the law is rapidly changing with regard to emergency laws and amendments to laws to provide for leaves that are paid in certain circumstances. Telecommuting issues. A lot of employees are becoming accustomed and being introduced to remote work when they maybe never have done it before. It raises a number of issues. We'll talk about expense reimbursements, about workers' compensation issues, and also about what your remote work policy should include. Orders to shelter in place. We've seen a number of those orders in California. We've seen sort of halfway measures like that in other parts of the country, and we should be prepared for more. And so we'll talk about those issues as well. And then we will talk about some mitigating measures, reductions in force, and other steps to start potentially thinking about, planning for, depending on where you are in your operations, and important considerations with regard to business contraction. So next slide. So the first topic, employers' obligation to provide a safe working environment. We could go to the next slide. So OSHA, the Occupational Safe and Health Act, covers most private sector employers and employees in the United States. There are exemptions, but most private sector employers and employees are covered by OSHA. OSHA provides that employers must furnish to each employee a place of employment that is free from recognized hazards that cause or are likely to cause death or serious physical harm. This is a general duty of care established by the Occupational Safety and Health Act. And questions are coming up now as to what does that entail? What am I required to do as an employer to provide a safe and healthy workplace for my employees and to keep it free from recognized hazards like the coronavirus, which is causing or likely to cause death or serious physical harm? So under this general duty of care, employers really are best served to comply with not only the CDC recommendations, but of course the ordinances, the orders, the laws, the guidance that is put out on a community, on a local level, on a state level, and on a federal level. There are a number of communities that have put out their own mitigation guidance that have requirements that go further than, for example, the CDC's interim recommendations and its guidance for business and employers. I would encourage all of you to check the CDC website and to continue checking the CDC website to make sure that you're up to date on the latest recommendations and guidance from the CDC with regard to the workplace and what employers should be doing to protect their employees. If you satisfy and you comply with the guidance and the recommendations of the CDC and of your local guidance, your state and federal laws and guidance, I think an employer will be well placed to say that they took all reasonable steps and satisfied their obligation under OSHA. So the CDC guidance, when you look it up on their website, is lengthy, and it covers a number of areas and issues that employers should be mindful of. I pulled out a few that I think are critical for us to review and have in mind. And they fall really in three buckets. One is communication. It is pivotal that employers provide clear, current, and consistent communication to their employees at this time with respect to COVID-19, with respect to employment policies and what the employer is doing, how it's responding as an organization. And to do that, we recommended before in one of our client alerts that companies should appoint a team or a manager responsible for coordinating communication efforts, for being in touch with and being on top of what the CDC and what the government and the local authorities are recommending, and healthcare authorities. Creating an employee resource link, for example, on the company's intranet to help employees stay current and know where to find information with regard to decisions the organization is making as the situation evolves, with regard to maybe emergency policies that companies are putting into place to deal with issues that are unique to the situation, with regard to communications to clients, to vendors, event cancellations, telecommuting issues. So communication, I would say, is one of the three things that is very important, and you'll see it runs through the advice and the guidance that is provided by the CDC. It should be clear, it should be current, and it should be consistent. And to do that, again, appoint somebody or a team to monitor the guidance that's being provided and to update your communication resources to your workforce. 2, your policies. The CDC says review your HR policies to make sure they are consistent with public health recommendations, with state, local, and federal laws and orders. So it's important that you review your policies, you update them as needed, and that you implement new policies that may be necessary in this circumstance with regard to, for example, telecommuting or expense reimbursement or employee leaves. You'll see with all of these new amendments to laws and orders coming out, they may impact your policies that you have in place with regard to paid time off, for example, and others. So be mindful of your policies, review them, keep them up to date, and consider whether you need new policies to deal with the current circumstances. 3, plan. Plan for how to handle employees who are infected or who may be infected based on symptoms or their contact. So you have to have a plan in place as to how you're going to proceed as employers, how you're going to treat your employees, both with regard to screening, what you're going to do with the results of the screening, and we'll talk about that more specifically on our point number 2 in this presentation, about people in the workplace who will be permitted, if anyone, in the workplace, and what steps you're going to take and how you're going to apply the actions that you put in place with regard to employees who are sick who are maybe sick, depending on their symptoms or on their contacts with others who are or who may be sick. So in those 3 buckets, I'd urge you to pay attention to communications, your policies, and your plans for dealing with employees at work, so that you can comply with the CDC's recommendations, and of course being mindful of special requirements that your community, your locality, your state may require. Going on to the next slide. What can an employer do to screen employees for COVID-19? Many of the questions, as I said, that we're getting from our clients relate to this issue. What can we do? So going to the next slide. The EEOC has stated that the Americans with Disabilities Act and the Rehabilitation Act rules continue to apply, but they do not interfere with or prevent employers from following the guidelines and suggestions made by the CDC or state or local public health authorities about steps employers should take regarding COVID-19. You'll see as we go through this presentation that there's a little bit of a relaxation in terms of the rules to permit employers to ask more, to do more, in order to screen and take care of employees who are or who may be infected with COVID-19. That doesn't mean that we throw all of the rules by the wayside. The ADA, the Rehabilitation Act rules continue to apply, as do rules on confidentiality and privacy and other issues, as I will highlight as we go on. So based on the current guidance from the EEOC and the CDC, during this pandemic, if an employee calls in or appears to be sick, you may ask the following questions to determine whether they may be infected. 1, are you experiencing any of the symptoms of COVID-19 identified by the CDC? And those are on the website, but they include things that you're probably familiar with by now, like fever, cough, shortness of breath, difficulty breathing, and some other symptoms. If the answer is yes, when did you start experiencing these symptoms? And I will reiterate this throughout, but you have to maintain all information about employee illness and their medical condition as a confidential medical record in compliance with the Americans with Disabilities Act. But you can ask those questions of employees to ascertain whether they are symptomatic of COVID-19. 2, have you been in close contact with anyone who has a confirmed case of COVID-19 or a suspected case of COVID-19? And 3, and this one I think is becoming a little less relevant as travel restrictions have been in place now for some time, and employees really aren't traveling for work to the heavily affected locations for the most part. But have you traveled to any country under a travel advisory due to the coronavirus outbreak, according to the US Department of State? So those 3 questions can be asked to screen employees. With regard to temperature scans, the ADA, the Americans with Disabilities Act, restricts disability-related inquiries and medical examinations by employers, except in certain circumstances. And requiring employees to submit to a temperature check constitutes a medical examination. Now, in 2009, when we were dealing with H1N1, the EEOC issued guidance in connection with that pandemic and said that, in relevant part, if pandemic influenza, this is in 2009, becomes widespread in the community, as assessed by state or local health authorities or the CDC, then employers may measure employees' body temperature. And the EEOC now says that that guidance from 2009 is still relevant today, and that it identifies established ADA and Rehabilitation Act principles to answer questions frequently asked about the workplace during a pandemic. And as you all know by now, the World Health Organization has categorized COVID-19 as a pandemic. And the EEOC states currently on its website, because the CDC and state and local health authorities have acknowledged community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. However, employers should be aware that some people with COVID-19 do not have a fever. Now, as much as that is very clear, it seems, that employers may measure employees' body temperature, keeping in mind that not everyone with COVID-19 will show a fever, there are some precautions, I think, that are important to keep in mind here. First of all, if you are going to do temperature testing, you should make clear that it is being used solely to determine if the employee has a symptom of COVID-19, as opposed to finding out medical information for some other reason or impairment or other purpose. The scope of the testing should be uniform. The testing and the response to the testing needs to be consistent. The company also should not use oral thermometers, which are considered to be more invasive. And I will note that a fever for CDC purposes and for our purposes for COVID-19 is defined as a measured temperature of 100.4 Fahrenheit or greater. And again, it may be a symptom of COVID-19, but it is not determinative. Someone may have a fever and it may not be COVID-19. They may have no fever and still have COVID-19. So it's not determinative. So I would also say be mindful of privacy. Now let's take a state like California, where employees have a constitutional right to privacy. In ordinary circumstances, I would tell you that you could not have your employees take your employees' temperature and have them report what the temperature is because of the right to privacy, among other issues. There is also confidentiality. As I said before, this would be a medical record. Whether the employee reports a temperature of 98.5 or whatever normal is considered today, or 100.2, that is a medical record that needs to be kept separate from their personnel file and maintained confidentially. And it's safer still, I believe, to do this thermometer taking, the temperature taking, if so, with employees' consent. All of that said, based on the EEOC guidance, and as I've said, it appears that the EEOC is giving employers more latitude and flexibility to do screening, including taking temperatures as part of the screening in this pandemic situation in order to protect its workforce and the public. We do have clients who are denying entry to employees if they refuse to have their temperature taken. And there's a question as to what to do with those employees who refuse to have their temperature taken. Are they sent home with an unexcused absence? Are they disciplined? Are they terminated? Do you find an off-site location for them to work? If they can telecommute, is that what happens to them? So there are some issues, and I would encourage you to reach out to us to talk with us one-on-one if you're considering mandating temperature taking at work for all employees, so we could drill down on some of these issues and make sure you are protected. What is the company response if an employee answers affirmatively to the three screening questions, or the person registers a temperature of 100.4 or greater? Well, according to the CDC, direct the employee to leave work immediately in self-quarantine. They should leave the workplace, and they should be directed to seek health advice to determine their need for a further medical examination. You should ask the employee to identify all individuals who worked in close proximity, at least 6 feet to them, in the 14 days prior to the onset of the symptoms. Those employees should be notified, and they can be sent home in the interim period while you're awaiting test results for that initial employee to see whether they need to be given further instructions and self-quarantine as well. You should also tell the employee to inform the company of the results of the testing, so you could see if the employee tests positive for coronavirus. If they are confirmed to have COVID-19, then you need to inform the relevant employees, those who have been in close contact, of their possible exposure. But again, maintain confidentiality as to the identity of the infected employee as required by the ADA. What happens when an employee it's time for them to return to work, they say, after having tested positive for coronavirus, for example? Well, ideally, we would require the employee to provide a doctor's note certifying fitness to return, or even more ideally, have them submit to another test to confirm that they are no longer positive for COVID-19. But as a practical matter, as you know, doctors and other healthcare professionals probably are too busy, and will be certainly as time goes on, to provide fitness for duty certifications and documentation. And everybody has heard about the difficulty that people are having getting tested, so it's not really realistic. And the CDC and the EEOC recognize that. So you can just follow the CDC guidance for when individuals may discontinue home isolation after being infected with the COVID-19 to determine when an employee will be permitted to return to work. And the CDC guidance is not requiring doctor certification or retesting. Instead, if you go to the CDC website, you will see what the criteria are based on the CDC guidance for when individuals can continue home isolation. And it's at least 3 days, 72 hours have passed since recovery, which is defined, and improvement in respiratory symptoms, and at least 7 days have passed since symptoms first appeared. So you can drill down on those specifics looking at the CDC website. You can, as an employer, impose lengthier waiting periods, but you have to be consistent on the issue to avoid a claim of discrimination. And I would also say, just going back to the temperature taking for a moment, and in this whole discussion here, to be mindful of claims for someone making a claim for being regarded as disabled under the ADA. They may be perfectly healthy, but because they show a fever or otherwise are symptomatic, they may be treated in such a way that they down the line may have a claim for having been regarded as disabled and discriminated against on that basis. Again, maintaining confidentiality of employee medical records. All information obtained from an employee related to their health status is a confidential medical record pursuant to the ADA. and the ADA requires that employee medical records be maintained confidentially and separate from the general personnel file. That includes medical exams, temperature data, benefit claim forms for disabilities, notes from doctors, even health-related information about an employee's family member. So be very mindful of that. And then to finish up on this issue, I wanted to just share with you 3 questions that are on the that the EEOC answered on its website that I think are important for you to know. If an employer is hiring, may it screen applicants for symptoms of COVID-19? The answer is yes, according to the EEOC. After making a conditional job offer, you can screen job applicants for symptoms of COVID-19 as long as you are consistent. You do it for all entering employees in the same type of job. 2, may an employer delay the start date of an applicant who has COVID-19 or symptoms associated with it? Yes. According to the current CDC guidance, an individual who has COVID-19 or symptoms associated with it should not be in the workplace. So the EEOC says, based on that CDC guidance, you can delay the start date of an applicant who has COVID-19 or symptoms associated with it. Further, based on current CDC guidance that I just articulated, the EEOC says you can withdraw a job offer if an individual has COVID-19 or symptoms of it. So you should check the EEOC's website. It has other very helpful questions and answers on this issue and practical advice. And with that, Kimball, if you could go to the next slide, and I'll turn it over to Matt Gorman.
Thank you very much, Marina. Here, and Kimball, you can switch to the next slide, please. So with the coronavirus affecting more areas of the country, we certainly expect that employee requests for time away will increase substantially. Employees who are sick or employees who have family members who are sick have multiple avenues for leave under state and federal law, both paid and unpaid leave. I'm going to briefly discuss a few of the laws that allow employees to take unpaid time away from work, and then Marina is going to discuss those laws that provide for paid time away from work. So first, the Federal Family and Medical Leave Act applies to employers with 50 employees or more. Employees who work for an employer of this size are eligible for up to 12 weeks of unpaid leave if they have worked for the company for at least 12 months, performed at least 1,250 hours of services during that 12-month period, and work at a location with at least 50 employees within 75 miles. Leave may be taken under the FMLA for the employee's own serious health condition or to care for a family member with a serious health condition. An illness like the coronavirus could be considered a protected serious health condition if an employee or their family member is incapacitated or receives continuing treatment from a doctor for more than 3 full consecutive days. As the most serious cases of the coronavirus often require multiple days of hospitalization, and even more mild cases can result in days of incapacitation, employers should be prepared to approve FMLA leave for employees who contract the virus or whose family members do so. Employers that are covered by the FMLA should refamiliarize themselves with their notice obligations and understand the process for evaluating employee leave requests and whether the FMLA applies in a given situation. If an employee does qualify for and then take FMLA leave, they're entitled to return to the same position or an equivalent position at the end of their leave. The potential return to work for an employee who contracted the coronavirus or who is caring for a family member with the coronavirus poses at least 2 important questions. First, what if the company had to engage in layoffs and the employee's position no longer exists? Under this scenario, employers should review the factors used to determine who would be included in the layoff and confirm that the employee's leave status was not used as a factor to determine if that employee should be included. If the employee would have been included in the layoff regardless of their leave status, the employer no longer has an obligation to return that employee to work, provided that there are no continuing obligations under a collective bargaining agreement or otherwise. The second question that we think will be prevalent when an employee is returning from an FMLA leave is exactly when it'd be safe to return to work. Marina discussed a lot of the health and safety considerations at play here, as well as screening measures, and returns to work under other federal laws. But given the reasons that an employee may take FMLA leave related to the coronavirus, we think that employers would benefit from exercising particular caution before allowing an employee on coronavirus-related FMLA leave to return to work. Accordingly, under the FMLA, employers may implement a uniform policy applicable to all similarly situated employees that they obtain a doctor certification before returning to work. The fitness certification requirement must be conveyed to the employee at the time of the initial FMLA notice. If the employer has questions about the certification, it may contact the employee's doctor to clarify and authenticate the return to work certification. Marina mentioned these previously, but certainly given the climate today and the very high demand for health care services, employers should be prepared for practical difficulties that may be inherent in obtaining that type of certification or in trying to clarify and authenticate the information and guidance in that certification. If there is a delay or inability to obtain a return to work certification and the requirement was clearly conveyed to the employee at the start of leave, employers would generally be better served exercising caution before allowing the employee to return to the workplace, and also be flexible in allowing an employee sufficient time to obtain the necessary certification or for clarifying or authenticating parts or all of the certification before returning them to work. Because of the largely unprecedented effects of the coronavirus on the workplace and the limited scope and protections of the FMLA, yesterday Congress passed the Emergency Family and Medical Leave Expansion Act. This is a temporary measure that expands the scope of the FMLA to address absences due to the coronavirus. Unlike the FMLA, this emergency expansion would cover all employers with 500 or fewer employees and lowers the threshold for employee eligibility to cover all employees who worked for the employer for at least 30 days prior to the date of leave. The Emergency Act does contain an exception, however, that would allow the Secretary of Labor to exempt small businesses with fewer than 50 employees if the leave would jeopardize the viability of their businesses. The Emergency Act also expands the permissible reasons for leave to be broader than what the FMLA provides. Employees who are unable to work or telecommute will be allowed up to 12 weeks of job-protected leave to care for the employee's child if the child's school or place of care is closed, or the child care provider is unavailable due to a coronavirus-related emergency declared by a federal, state, or local authority, such as the national emergency declared by the president, and similar declarations that we've seen from state and local governments across the country. Employers should note that this permissible reason for leave is significantly narrower than what was originally proposed in the bill passed by the House of Representatives a few days ago. Under the emergency measure, the first 10 days of leave are unpaid, but employees may elect to substitute any accrued vacation or other paid time off for the unpaid days during this portion of the leave. Any remaining leave would be paid, and while the rates and calculations of payment will differ for full-time and part-time employees, under no circumstances will employees receive more than $200 per day or more than a total of $10,000 over the course of their emergency leave. Employers are eligible to receive tax credits for making these payments to employees. Employers with 25 or more employees have the same obligations as they do under the FMLA to restore an employee to the same or equivalent position once the employee's leave is over. Employers with fewer than 25 employees are exempted from this requirement if the employee's position no longer exists due to economic conditions or changes in the operating conditions of the employer caused by a public health emergency, such as the coronavirus. These employers must, however, make reasonable efforts to restore the employee to the same or equivalent position over the earlier of the 1-year period beginning as of the end of the declaration of coronavirus as a public health emergency, or the date that is 12 weeks after the start of the employee's emergency leave. The emergency measure also contains a paid sick leave requirement that Marina will discuss momentarily. The emergency measure goes into effect on April 2nd and will expire at the end of this year. Although the federal government has now expanded the scope of coverage under the FMLA, neither the FMLA itself nor the emergency measure will apply in all situations where an employee may be absent due to the coronavirus. For this reason, employers should also understand whether any state or local laws provide for unpaid leave. There are many states and municipalities that have enacted sick leave laws, generally providing for up to a few days per year in sick leave that employees may use. Most such statutes provide for paid leave and will be discussed by Marina, but some of these statutes impose requirements for unpaid sick leave for employers under a certain employee threshold. For example, New York City has its own paid sick leave law that applies to employers with more than 5 employees, but employers under that threshold must still provide the same amount of sick leave, albeit unpaid. We're actively monitoring efforts to expand these sick leave laws to provide for greater benefits or to apply in situations specific to the coronavirus, such as if an employee needs to be quarantined. States like California also have their own family and medical leave statutes that may apply in situations where the FMLA does not, and which also may be amended in the coming days or weeks to address the coronavirus pandemic. Finally, unpaid leave may also be available as a reasonable accommodation for a disability under federal and state law. Temporary conditions like coronavirus typically would not be considered disabilities under federal law, but may fit the statutory definition of a disability in states like California and New York, where the concept is defined much more broadly than under federal law. In addition, if there are any lingering effects or permanent effects of absence due to coronavirus, the conditions may be considered a disability under federal law as well and should be considered in that light. This is another potential area where legislatures may take action to clarify disability discrimination statutes and to expand them in light of the coronavirus pandemic. We have not yet seen any specific movement in that area, but it's another place that we're monitoring actively. I'll now kick it back over to Marina to talk about some paid leave statutes that may come into play here.
Great, thank you. In addition to the new federal legislation that Matt went over, there are a number of states who provide for paid leave. I'll give you some examples. California paid family leave provides benefits to employees who need to take time off from work to care for a seriously ill, a long list of relations: children, parents, parents-in-law, spouses, registered domestic partners, and others. It does not provide job protection, only benefits, but you have job protection under the FMLA, California Family Rights Act, and others. New York has a paid family leave law. It can be used to care for a child of any age. Also, there's paid sick leave in states like California. If an employee has paid sick leave available, the employer must provide the leave and compensate the employee. And that paid sick leave can be used for absences due to illness, the diagnosis, care, or treatment of an existing health condition, or preventative care for the employee or the employer's family member, which may include self-quarantine, where there's been exposure to COVID-19 or where the worker has traveled to a high-risk area, for example. There's also vacation and PTO, and that's policy-driven. It depends on what your policy says, but an employee can take PTO or vacation if it's available to them and also have compensation during their leave under those circumstances. Remember that an employer may be able to require employees to use their vacation or PTO, depending on their policy, but they cannot require that the worker use paid sick leave. That's the worker's choice. We did a client alert just yesterday on New York expanding its paid sick leave in light of COVID-19. I would urge you to review that. It's very detailed, and it provides for when payment and paid leave is available, broken down onto really the size of the workplace. Employers with 100 or more employees, there are certain rules, different rules if you have 11 to 99, and going down. And then as you get down to fewer employees, your revenue also matters to determine whether there is coverage there. And generally speaking, there's some allotment of paid sick leave for employees who are subject to a mandatory or precautionary order of quarantine or isolation due to COVID-19. And again, the details are in our client alert. There are exceptions that we also detail, and there is a right to reinstatement. So you can't terminate employee for taking that leave or threaten to or penalize them in any other way. I will also mention in terms of buckets of potential pay for time off in these circumstances, there is short-term disability that might come into play for an aggressive infection. Check your individual employment agreements that you may have with some executives or others, and collective bargaining agreements, which may provide for paid leave under certain circumstances. There is also unemployment compensation, and some of you may have seen an executive order that was signed by Governor Newsom in California that waived the 7-day delay for unemployment compensation for Californians who are have an employment loss because of the coronavirus. And that applies if your hours are reduced due to quarantine, if operations are shut down due to COVID-19, whereas typically people who apply for unemployment when they're laid off have to wait a week before the benefits kick in. He took care of that with an executive order in California. He also relaxed employment search obligations for certain people who lose their jobs temporarily due to some sort of coronavirus related event. And if we go to the next issue, which is telecommuting, and to the next slide. We are preparing a telecommuting policy, a remote work policy that'll be available through 650. And I encourage you to look at that and consider that, because it'll touch on what we think is really material and key in the context of a telecommuting policy. And some of those issues are highlighted on this slide. You want to make sure that there's compliance with wage and hour requirements for non-exempt employees. We don't want to be here a year later with the non-exempt employees who worked from home saying, I worked overtime every day, I worked 7 days a week, I didn't take my meal break and all of that. So you have to put a policy in place to protect against that, whether that is agreed upon hours of work and they can only work those hours, and make sure you don't email or call them or ask them to do anything outside of those hours. I know I will tell you at our firm with our assistants who are working remotely, they're required to send an email to the attorneys and the other people they're working with every day to indicate when they start working, when they stop working, when they go to lunch, when they come back from lunch. So you need a way, you need to put a schedule into place and to make sure you're mindful of the wage and hour requirements, which are not relaxed just because the employees are telecommuting. And also important is having a record of the time that they're working so that you're not caught without any response or any ability to substantiate your position later. So, people are still required, if they're non-exempt, to take meal breaks and rest breaks and things like that. Here, for example, people use an out of office message when they're out on breaks, have them log and tell you when they're taking PTO. You should also have expectations regarding responsiveness. Respond to every email or phone call within 2 hours, for example, to make sure people are actually working and are attending to their work throughout the day. And the policy can also mandate daily phone calls at a certain time, or video conferences, or daily or weekly status reports or goals. Some people are taking equipment home that's becoming necessary, whether it's your desk chair or your monitor or whatever it may be. And of course, employers are being flexible with that so that people can work from home, but you want to log what those things are and make sure you get them back when this is all over. If employees can or must use their personal electronic devices, you have to be mindful of the confidential information they're accessing and working with and storing on those personal devices. Now is the time to take a look at your policy with regard to personal electronic devices. Make sure you have an audit right in there. So again, when this is over, or even before this is over, if there's a need, you can audit personal devices and make sure you recover your confidential information and it hasn't been misused. And again, this is a good time for a reminder about employees' responsibilities to safeguard the company's confidential information and to make sure you get it back, that it's returned, again, when you call for it or when people start coming back to work. And Matt, we can go to our next slide on reimbursements.
Great, thanks, Marina. I think this topic dovetails nicely with what Marina was just discussing in terms of telecommuting. I think that we've seen, whether mandated or not, that most or all employees at companies are moving to telecommuting, at least for the foreseeable future. And in connection with that move, we expect that there will be a significant number of requests to be reimbursed for new and different types of expenses incurred through working at home, expenses that may not have been contemplated previously while all employees were in the office. The first thing we'd recommend employers doing is reviewing their policies and applicable employment agreements at issue. There are a few states that have specific laws requiring the reimbursement of business expenses. So in most circumstances, though, employers will need to ensure they're following their own internal policies, as well as provisions in their employment agreement that provide for business expense reimbursement. Regardless of whether there's already a written policy in place, we think employers would be well served reconsidering those policies in light of the current situation and the critical mass of employees working from home. One reason for this is that states like California are one of the few that have statutory provisions requiring reimbursement of business expenses. And as a result, employees may now be entitled to reimbursement for a broad range of expenses not previously considered when they were working in the office. Specifically, California Labor Code Section 2802 obligates employers to reimburse employees for all necessary expenditures or losses incurred by the employee in direct consequence or discharge of his or her duties, or of his or her obedience to the directions of the employer. This statute has previously been interpreted to require employers to reimburse employees for the reasonable share of an employee's mobile phone bill attributable to work for that employer. Extrapolating from this case, California employees may also be entitled to reimbursement for similar expenses incurred while telecommuting, such as a reasonable portion of their monthly internet bill, as well as the cost of other equipment and supplies that an employee reasonably needs to work from home. To avoid any confusion or disputes as to what expenses will be reimbursed, we recommend that employers require employees to seek advance approval before submitting telecommuting expenses for reimbursement and imposing reasonable limitations on the amounts which will be reimbursed for certain expenses. For employees who are required or asked to work from home, employers should consider whether to implement guidelines about the work to be performed and the manner in which it will be performed in order to limit the types of expenses that may be considered necessary for the employees to do their jobs. To the extent possible, employers may also have a conversation with the employees beforehand to discuss what types of expenses may be incurred and come to an understanding on the reimbursement process. Employees should also consider whether to expand their reimbursement policies to reimburse employees for expenses incurred in safely getting to work to the extent employees are coming in. Such expenses may include the cost of an Uber or Lyft to get into the office if the employees would otherwise need to take public transportation. If employees are required to incur other expenses in order to safely perform their jobs while in the office, those expenses may also be subject to reimbursement, and we recommend being flexible and considering those requests on a case-by-case basis. Employers may also consider whether to adopt a new expense reimbursement policy that specifically enumerates those expenses which will be reimbursed and those that will not be reimbursed so as to limit the number of disputes on this issue. When considering which expenses are subject to reimbursement, employers should be mindful of Labor Code Section 2802, which I just noted for their California employees, as well as Illinois, Massachusetts, New York, Pennsylvania, and Washington, D.C. statutes that may affect which expenses are subject to reimbursement and when reimbursement may be made. And we can move on to the next slide now.
Perfect. Thank you, Matt. And Marina, let me just jump in here and say, this is Kimball Parker from 650. Marina mentioned we are working with Marina and Matt to automate some of these policies. We're going to offer those for free through 650 starting next week. So we will be in touch about that. But wanted to make that clear. So Marina, thank you.
Yeah, thanks, Kimball. I'm glad that you highlighted that and pointed it out. I'll be talking now briefly about workers' compensation, another issue that I think comes up when more employees will be telecommuting and working from home. I think that those arrangements bring additional challenges and questions for the application of workers' compensation. As an example, employers may be liable for injuries sustained by employees when they're working from home. Although the workers' compensation statutes will differ somewhat by state, an employee injury or illness will generally be covered by workers' compensation if it arises out of and is sustained within the course of employment, regardless of where that injury occurs. Using just California as an example, the standard for employer liability is that an injury or illness is work-related if an event or exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. Determining whether an injury or illness suffered by an employee will be fact-intensive. As a general matter, though, an injury will be considered to be work-related if it occurs while the employee is performing work in their home and the injury is directly related to the performance of the work rather than to the general home environment or non-work-related activities. By way of an example, if an employee trips over a toy or the family dog while answering a work phone call, the resulting injury would not be covered by workers' compensation. The same is true if an employee burns himself while making lunch during the workday, or if an employee chokes on their lunch during a conference call. Still, employers have an obligation to ensure that any employees working from home maintain a safe work environment while telecommuting. We recommend clearly communicating this requirement in a written policy acknowledged by the employees. The policy should also establish guidelines for the home office space and may include standards for the working station. Employers may also want to require periodic confirmations from employees that the work environment is maintained as safe and without hazards. If there's a particular concern, employers could also perform a televisual inspection of the work environment when an in-person review would not be appropriate due to the coronavirus and the social distancing practices that we should be engaged in. Employers should also prohibit employees from meeting with customers or clients or other employees in their home, both for purposes of limiting exposure for injuries or illnesses suffered and to maintain proper social distancing related to the coronavirus. Under these exceptional circumstances, it may also be appropriate to ensure that employees prohibit others from entering their home work environment unless the employee knows that they're taking proper precautions against the coronavirus. Marina mentioned this in the context of non-exempt employees and setting hours, making sure they're taking meal and rest breaks, and keeping those guidelines and records in place. Doing so may also be helpful for workers' compensation claims. To the extent employees are given guidance and advised only to work certain hours, that can indicate whether an injury or illness occurred during the course of employment or occurred outside of their normal working hours or when they were told to be working for the employer. A more difficult question may arise for employees who have a family member or a housemate with the coronavirus or who suspects they may have the virus and needs to self-quarantine. In such a situation, it might not be unreasonable to tell the employee that they should not work at all due to lack of a safe working environment. This, of course, should be evaluated on a case-by-case basis, but it is more reasonable to require an employee to telecommute if they have a separate room in a house with a home office versus an employee who shares a studio apartment with their sick partner. At the least, employers should explore options for ensuring that the employee can continue working at home in a safe environment where they can reasonably limit their potential exposure to someone who contracted or may have contracted the virus. This may include confirming with the employee that they have a workspace that can be maintained separately from their sick family member or roommate. Employers would also need to evaluate whether the employee may be entitled to take leave if they have a sick family member, including for purposes under the emergency FMLA expansion that I discussed a little bit earlier. We can go on to the last slides now.
So orders to shelter in place, and we can go to the next one, Kimball. So, we've had these orders to shelter in place issued by a number of counties in California, and they're more and more as the days go on. And we've had a lot of questions from individual businesses. Is my business impacted by a shelter in place order? If so, do we have to shut down? What minimum business operations can we keep running? So it really depends on what the particular order in your location provides and what your business does. It's a very specific inquiry. At this point, we have a number of counties in the San Francisco Bay Area that have had shelter-in-place orders, others in Monterey and Davis County, and some others that I saw since then. And the first that came out in the 6 counties in the San Francisco Bay Area were virtually verbatim. Some of the other ones deviate in some regards. They're less clear than the initial orders. But what I will say is you have to carefully read the exceptions, consult with counsel if necessary, to determine whether your business fits into an exception or must actually shut down or to a degree as defined in the order, whether you're permitted to continue operating minimum business operations and what that means under the order, and how you should treat employees who can't afford to work from home. That last topic is obviously not covered in those orders, but it is something that I wanted to hit on here because we have talked about leaves of absence, both paid and unpaid, new legislation. There is this situation where there could be a shelter-in-place order or a shutdown because of some other obligation or just because the employer feels like that's the prudent thing to do. I have clients like that too. And employees cannot telecommute because of the nature of their work or other circumstances. Or an employee can't work because their children's school was closed or they can't work all day. Is there anything that anything else than what we've talked about that is relevant here? And I will say that under the California Labor Code section 230.8, school activities and emergency leave. In California, employers with 25 or more employees working at the same location have to permit employees to take time off for certain child-related activities, including school emergencies, which would include our situation today. The California Division of Labor Standards Enforcement has specifically addressed school closures in a recent COVID-19 FAQ, which I urge you to take a look at, and provides details about Labor Code Section 230.8 and its applicability in this circumstance. It's 40 hours each year, up to that for school activities. Employees are usually limited to 8 hours per month, but that limitation does not apply to emergencies. And there are other details there that I would urge you to take a look at. In addition, we did mention there is unemployment compensation. So employees who have their hours reduced for reasons related to COVID-19 may be able to partially recover their wages by filing an unemployment insurance claim. And then I know we just have a few minutes, but I did want to go to the next slide, which is our last topic, and talk about financial mitigation measures as businesses think about whether they might need to contract and what steps and things they can be thinking about in planning for those contingencies. Matt?
Yeah, thanks very much, Marina. You know, as you mentioned, I think that one of the unfortunate realities of the economic situation resulting from COVID-19 is that many businesses will be looking to implement immediate and possibly significant cost-cutting measures. One obvious result is that there may need to be layoffs, but there are also a number of intermediate measures that employers can take to preserve jobs while still cutting costs. So I wanted to talk through a couple of those and discuss the implications and potential issues in taking those steps. The first thing, though, that all employers should keep in mind is that employees may not work for free. Even in times like this, wage and hour laws have not been suspended or relaxed, so all employers must follow the minimum wage requirements applicable in their particular jurisdiction, as well as other state and federal laws governing payment of overtime, timing of wage payments, and the manner of wage payments. There's no safe harbor for violating these laws at the employee's request. Violations would not be permissible if the employee consents in writing, or even if they sign a release of claims promising not to sue the company for paying less than minimum wage. Along similar lines, employees may not agree to volunteer their time. They may not agree to transition to an independent contractor unless that classification is legitimate. They may not agree to defer payment of their wages subject to some future condition, such as receiving a large payment from a customer or additional financing, nor may employees accept payment solely in stock or other non-monetary benefits. Even if employees are completely willing to accept one of these alternatives and unequivocally confirm their acceptance and release, companies and individuals subject themselves to the threat of significant liability for implementing one of those approaches in violations of wage and hour laws. Not only may employees recover significant penalties, including attorney's fees and punitive damages, officers and directors may face individual liability as well for any part they play in these decisions. We would certainly encourage officers and directors of any companies considering those possibilities to receive guidance on the particular circumstances at issue before moving forward with one of those approaches or any other measure that may violate wage and hour laws. There are still many lawful steps that employers can take to reduce the financial burden on the company. First, employers may implement prospective salary reductions for some or all employees. The reduced salaries must still comply with minimum wage and exempt salary requirements, but so long as they're implemented prospectively and with notice to the employee, a salary reduction is a legally viable option. The salary reduction may also be combined with an agreement to pay a conditional bonus based on a future event, such as the receipt of funding, as a way to make employees whole in the future. Any provision providing for such a bonus, though, should be drafted carefully and only after consultation with an attorney. Any salary reduction should also only be implemented after reviewing applicable offer letters or employment agreements to ensure that such a reduction is contractually permitted and that it would not trigger any severance obligations. It's common for agreements with executives or other senior employees to contain a good reason resignation clause that could permit individuals to resign under certain circumstances and collect severance. Typically, such a good reason clause would include a situation where the employee's salary is decreased to a material degree, usually more than 10% of the employee's prior salary. Employers should understand, therefore, if a salary reduction would trigger those severance obligations. The failure to pay contractually obligated severance is another situation where officers and directors may incur individual liability if the severance is not paid within the applicable time period. Second, employers may also take temporary measures to alleviate their financial burden, such as furloughing a group of employees or instituting a temporary shutdown. This step should only be considered in light of the employees at issue and based on a determination of which employees may be affected. For example, non-exempt hourly employees will be impacted differently than exempt salaried employees, and the timing of any furlough should account for this, so that employers do not obligate themselves to paying the full amount of an exempt employee's salary during the week that a furlough goes into effect. During furloughs, employees should also be relieved of all job responsibilities so as to avoid creating obligations to pay employees for work performed during the furlough. That goes for non-exempt employees too. Furloughs also should not be indefinite. In California, there's somewhat conflicting or different guidance on this, but as a general rule of thumb, employers should think that a furlough should not last more than 10 days, as that could be considered a termination of employment and thus trigger associated obligations, including the payment of final wages, accrued and unused vacation, and potential waiting time penalties for failure to pay the final wages on time. Finally, when considering a furlough or temporary shutdown, employers need to consider whether the decision may trigger WARN if the office remains shut down or the employees remain out of work for a significant period of time. There are a variety of other measures that employers may take as well, including forcing or offering vacation for a certain period of time, reducing employee hours or the regular work week, or allowing employees to take a temporary paid leave of absence at a reduced salary. One advantage of this latter measure may be the ability to pay employees less than the minimum wage or minimum exempt salary, since no work will be performed. Employees on a paid leave may also be able to continue vesting in stock options and remain on company benefit plans. This option, though, should be carefully considered, as an extended period of leave may eventually be considered a termination of employment and possibly trigger payout of vacation and other statutory termination obligations that I just mentioned. Unfortunately, it may be unavoidable that some companies will need to undergo layoffs rather than rely on these other cost-cutting measures. When conducting layoffs that affect 2 or more employees, there are a number of different factors that companies will need to consider, including any Form 8K filings, WARN Act obligations, contractual severance obligations or severance plans, accelerated vesting in retirement accounts, COBRA obligations, potential cancellation of group health insurance benefits, and potential disparate impact claims. I want to talk briefly about the WARN Act in terms of the consequences of a layoff. I think Most employers understand that there's a federal WARN Act that requires advance notice in case of a layoff that affects a certain number of employees. The federal WARN Act requires employers provide 60 days of advance written notice to employees, employee representatives, and certain governmental entities in the case of a mass layoff or plant closing. That statute applies only to employers with 100 or more employees and will be triggered under 3 scenarios. The first is a closing in which 50 or more employees suffer an employment loss. Second is a layoff affecting 50 or more employees if those employees constitute at least 33% of the employees at a certain employment site. And 3, if 500 or more total employees are laid off. Federal WARN may still be triggered by a reduction in force or a closing that affects fewer employees. In determining whether the Federal WARN Act applies, employers will also need to look ahead 90 days and look back 90 days to see if separate actions that would not trigger WARN when considered individually would trigger WARN when aggregated together. Employers should also remember that many states have their own mini-WARN statutes that apply in broader situations than the Federal WARN Act. For example, California WARN applies to any facility that employs 75 or more employees or employed 75 or more employees in the past 12 months. California WARN will also be triggered by a plant closing of any size and in the case of a layoff affecting 50 or more employees, regardless of the percentage of the workforce affected. The New York WARN Act covers even more employers as it applies to any employer with 50 or more employees. The statute also requires 90 days advance notice, not 60, in the event of a triggering event. The threshold for triggering WARN is also lower in New York. It applies to a closing affecting 25 or more employees, or a layoff affecting 25 or more employees if those employees make up at least 33% of the workforce. Employers who violate WARN would be liable for all back pay and benefits that should have been provided during the notice period, as well as potential statutory fines and attorney's fees. There are, however, 3 exceptions that may be applicable to layoffs and closings necessitated by the coronavirus. First, the faltering company exception. 2, the unforeseeable business circumstances exception. And 3, the natural disaster exception. While there are nuances in the factors and the application of each exception, these 3 also apply in New York, while California has the faltering company exception and the natural disaster exception. As indicated by its name, the faltering company exception may apply when the company has to conduct a plant closing due to financial circumstances. The company may be able to avoid the WARN requirements if, as of the time that notice would have been required, the employer was actively seeking capital or business which, if obtained, would have enabled the employer to avoid or postpone the shutdown, and the employer reasonably and in good faith believed that giving the required notice would have precluded obtaining the needed capital or business. For purposes of the unforeseeable business circumstances exception, the hallmark of foreseeability is whether the circumstance is caused by a sudden, dramatic, and unexpected action or condition outside the employer's control. The federal WARN regulations explicitly recognize that a dramatic major economic downturn may be considered a business circumstance that is not reasonably foreseeable. Successfully invoking this exception requires the employer to exercise commercially reasonable business judgment, as would a similarly situated employer in predicting the demands of a particular market. Finally, although by statute the natural disaster exception applies only when a flood, earthquake, drought, storm, tidal wave, or similar effect of nature is a direct result of the closing or layoff, the unprecedented and pandemic nature of the coronavirus may lead to a more expansive interpretation of this exception if neither of the 2 previous exceptions apply and the employer can demonstrate a good faith effort to otherwise comply with the WARN Act. If an employment action might trigger WARN and the company believes it may fit within one of these exceptions, we recommend speaking with an attorney to determine if the company can make a reasonable showing that one of the exceptions applies under both federal and state law, if applicable. The exceptions require a fact-intensive analysis and should be carefully considered so as not to unnecessarily trigger WARN. It's important that employers also keep in mind that the faltering company exception applies only in the context of a closure, not a layoff, and that the exceptions may not apply under the WARN Act in every state. It's also important that employers understand that fitting within an exception does not mean that the need for notice is obviated altogether. Instead, employers will need to give as much practice to employees and the governmental entities, including a brief statement as to why the notice period was reduced. The WSGR will also be keeping an eye on legislative updates to these statutes made in acknowledgement of the coronavirus pandemic. For example, Governor Newsom in California yesterday issued an executive order which effectively suspends the requirements and penalties of the California WARN Act for all qualifying California WARN terminations after March 4th if those terminations are coronavirus related and were not reasonably foreseeable. Employers will still need to provide the notices required under California WARN with as much notice as practicable. And like I said a minute ago, those notices will still need to include a brief statement of the basis for reducing the notice period and a statement to the employees about their eligibility for unemployment insurance benefits. The order does not obviate the requirements under federal law, so employers should still consider whether that WARN Act applies as well. I know we went a little bit long here, but I appreciate everybody staying with us and logging on for this webinar. That was the end of my presentation. We really appreciate the attendance, and both Marina and I are here to answer additional questions that came up from what we discussed in the presentation or any others that may arise from the effect of the coronavirus in the workplace.
Thank you, Matt. Thank you, Matt and Marina again. So I think what we are going to try to do is we've received a lot of questions on the webinar. We're going to gather those, look at them, and then see if we can kind of send those out after the webinar with some answers, if that's possible, or we will put you in touch with Matt and Marina directly. Again, we are working with Matt and Marina to draft policies to automate some policies that hopefully will be helpful to you. Again, we're looking to kind of release that next week, so we'll keep you informed. But some of the policies that they mentioned today, like a telecommuting policy and a reimbursement policy, et cetera, again, we're going to automate through 650's automation system and make it available for free. And so again, we want to keep you informed with some of the best experts in the field. Thank you so much, Marina and Matt, for taking the time to give us all that helpful information. And if there are any changes or any additional updates, we'll look to pull in Matt and Marina again to keep you kind of on the cutting edge of this issue. So thank you so much for joining. Again, we're going to send out some ancillary materials. We're going to send out the slides. We're going to send out a link to this webinar and hopefully some question and answer material there, as well as some material that Matt and Marina have released previously on the pandemic. So thank you so much, and stay safe, everybody. We will try to keep you up to date and informed on this issue and how to deal with it legally. Thank you.